The Sources of Nazi Knowledge of American Law. A tantalizing question about the meeting remains. Where did the participants get their information? What has become of the thoroughly comprehensible synoptic presentation of American race legislation that Gertner presented at the meeting? What was the source of the list of the laws of the 30 states that Freisler mentioned? The originals of the document or documents in question have doubtless perished, but they can be reconstructed with fair confidence, and they tell us some interesting things about the diffusion of American racist ideas in the mid-20th century. It seems likely that Gertner and Freisler were relying in part on a table listing the law of the American states that was published a few months later in the National Socialist Handbook on Law and Legislation, to which I will return shortly. As for the ministry's memo, it is clear that it drew on the research of a man I have already mentioned several times, Heinrich Krieger, to whom a reference was later added in a redacted version of the stenographic transcript, and it is important to turn for a moment to Krieger's biography, for knowing Nazi engagement with American law in the early 1930s means knowing Heinrich Krieger. Krieger was a young Nazi lawyer who had just returned to Germany from Arkansas, where he spent 2 semesters as an exchange student at the University of Arkansas Law School in 1933 to 1934. He was deeply immersed in American law, so much so that in 1935 he published a well-wrought English-language article in the George Washington Law Review titled Principles of the Indian Law. When he returned home to the Germany in the throes of the National Revolution, he benefited from the sponsorship of Otto Kohlreuter, among others, and became a fellow at an academic institute in Düsseldorf under the control of Frick's Ministry of the Interior. It was during his time in Düsseldorf that Krieger's work came to the attention of Gertner's Ministry of Justice. He published his magnum opus on American law, Race Law in the United States, in 1936, and then left Germany once again to continue his research on foreign race regimes. Joining the National Socialist Office of Race Policy, he traveled to Southwest Africa, where German colonial administrators had first investigated the American race law model 30 years earlier. Krieger spent 2 productive years in Africa, publishing studies on local race law and the treatment of indigenous legal traditions, while collecting research for an extensive monograph on South Africa, a Nordic state, as he wrote, that was on the road to becoming a great power. He returned to Germany in 1939, just in time for the outbreak of hostilities, and served with the forces of his country in a war that he described as perhaps the most important turning point in the entire evolution of the race question. After the war was lost, Krieger's life took a new direction. In the 1950s, we discover him as a prominent school teacher with a changed profile. He has become a vocal proponent of international understanding and peace, advocating for European unification while organizing student exchanges and aid for developing countries in Africa and Asia. What internationalist Krieger of the 1950s had to say about his younger Nazi self, we do not know. The writings of his youth showed a deep allegiance to Nazi values. They also showed Krieger's command of the finest techniques of advanced German scholarship. Nazi law was marked by a strong commitment to what Americans call legal realism, the style of legal scholarship that also dominated in New Deal America. I will return to the comparison between these 2 legal realisms in the conclusion. Legal realism in the 1930s was an approach that looked beyond the black letter of the law in the effort to grapple with larger social and cultural forces. The young Krieger was a prime representative of the Nazi strain of realism. Indeed, his interpretation of America is one of the more impressive examples of Nazi writing in the realist vein. Krieger's work interpreting American law begins with his George Washington Law Review article on Indian law. This was a legal realist study whose aim was to identify the underlying social values that could explain what otherwise would seem incoherent black-letter doctrine. The young Nazi lawyer, profiting from his year of research in the law library at the University of Arkansas in Fayetteville, presented a careful and learned review of the history of American Indian law, whose point was to expose the ultimate incoherence of the formal law. There was only one way to make sense of the jarring contradictions in American Indian law, Krieger argued. It simply had to be understood as a species of race law, founded in the unacknowledged conviction that Indians were racially different and therefore necessarily subject to a distinct legal regime. The article makes for sinister reading in light of Nazi history. Setting up a distinct legal racial regime for the Jews was, of course, the core idea of the Nuremberg Laws, and the American treatment of the Indians was later to be invoked as a precedent for German conquests in the East. What horror we all ought to feel when we learn that Hans Frank referred to the Jews of Ukraine as Indians in 1942. But while Krieger's interpretation may have been sinister, it was not stupid. There is nothing foolish about detecting racism at work in American Indian law. His Race Law in the United States was another work that cannot be called stupid. That book, filled though it was with ugly Nazi judgments, was a work of real learning and numerous insights. Heinrich Krieger was, as it were, the Nazi Gunnar Myrdal, and his book would deserve at least a partial translation today. In it, he provided an account of American legal history presented against a richly described socioeconomic background. The book makes for startling reading today. Startling, if for no other reason, because Krieger's heroes were Thomas Jefferson and Abraham Lincoln. Race law in the United States was the legal companion to the Nazi world histories that credited the founding with the creation of the strongest prop for the Aryan struggle for world domination. It was a heroic interpretation of American history as a long, though deeply troubled, struggle against race mixing, led by America's greatest presidents. Jefferson was already featuring in Krieger's work in 1934, which highlighted his 1821 declaration of the impossibility of racial coexistence. It is certain that the two races, equally free, cannot live in the same government. Race law in the United States added an account of the Civil War era that included an exact and lengthy documentation of Lincoln's pre-1863 declarations to the effect that the only real hope for America was the resettlement of the black population elsewhere. This was telling material in the Germany of the Nuremberg Laws. The Nazi policy with regard to the German Jews was precisely that they must be driven out of the Reich. Lincoln was Krieger's exemplary statesman, to whom he referred reverently. He maintained that America could have become a truly healthy race-based order if only Lincoln, wise in the knowledge that the races could not inhabit the same country, had not been assassinated. Krieger's villains were the radical Republicans, and his ultimate diagnosis of America in the 1930s was another piece of Nazi legal realism. The radical Republicans had saddled America with the highly formalistic jurisprudence of the 14th Amendment, founded on an abstract concept of equality foreign to human experience and certainly foreign to the basic racist worldview of the American populace. The result was that American law was torn between two shaping forces: formalistic liberal egalitarianism and realistic racism. It was to be hoped that realistic racism would ultimately win out. This was certainly a deep, distasteful reading of American legal history, but there were plenty of Americans who believed something like it at the time, both in the North and in the South. Krieger's book was moreover buttressed by 350 pages of detailed study of American statutory and decisional law, accompanied by statistical and qualitative studies in American society, and it was rich in theoretical sophistication and acute observations about workings of American legal racism. It may sound grating to speak of first-rate Nazi scholarship, but that is what Heinrich Krieger's race law in the United States represented. Krieger was only one of many fine legal scholars whose gifts did not immunize them to the draw of Nazism. The transcript of the June 1934 planning meeting shows the stamp of young Krieger's influence. The material that Gertner quoted most likely came from research included in another Krieger article, also titled Race Law in the United States, published in mid-1934 in a technical journal of administrative law, the Verwaltungsarchiv, and thereafter regularly cited by Nazi policymakers. That article is a compendium of what was known in Germany in the summer of 1934. Krieger reviewed for his readers the harsh tenor of American anti-miscegenation law in the early 1930s. The attempt to enter into an unlawful mixed marriage has the almost universal legal consequence of both invalidity and exposure to criminal punishment. With regard to the first of these consequences, the statutes use the following terms, either individually or in combination: void, unlawful, null, illegal, absolutely void. The reach of the civil invalidity is not defined in a uniform way, but illegitimacy and incapacity to inherit of the offspring are the regular results. Violations of these marriage prohibitions are threatened with both fines and imprisonment. Statutes that provide for both forms of punishment sometimes permit both to be imposed, sometimes threaten them in the alternative. There is a corresponding variation in the grading of the offense, for example, misdemeanor in Nevada, felony in Tennessee, felony, infamous crime, in Maryland, and in the measure of punishment. In several states, imprisonment of up to 10 years may be imposed. In others, 6 months is the highest possible sentence. In a few states, Missouri, Indiana, the law expressly uses the concept of knowing violation of the law, a provision that rests on the recognition that there is widespread ignorance of the descent of individuals. It was presumably this passage, or some version of it, that Gertner had before him at the June 5th meeting. Krieger's article also made a point of emphasizing the open-ended and not very sharply juristically defined approach of American law, dwelling on the fact that American law was content to divide the population into two fundamentally arbitrary categories, white and colored. Like Freisler, Krieger emphasized that there was nothing scientific about these concepts. The two categories were the product of artificial line drawing, not race reality. Nevertheless, American law was able to manage as it wrestled with the same critical problem as Germany: how to treat mongrels. The problem of the legal treatment of mongrels has received a simple solution, at least from the point of view of American statutory law. A fundamental distinction is made between only two population groups, whites and coloreds. All of the concepts used in the regulations accordingly involve artificial line drawing, partly by statute, partly by the courts. Implicit in this was the point made by Donani at the June 5th meeting. The fact that there were only two categories meant that American law lumped Jews in under the heading Caucasian. As Krieger would explain in Race Law in the United States, this was because the United States had, so far, not gotten around to the Jew problem. In his 1934 article, however, Krieger did not pause over the question of the Jews. Like Gertner and Freisler, he simply moved on to what was interesting in the many techniques that the American states used for addressing the definitional challenges posed by their enormous mass of mongrels. For the most part, Krieger reported, the states looked to descent defined by fractions of blood, but they sometimes took other tacks as well. States that draw racial distinctions determine membership in the colored group either according to degrees of descent from a colored descendant or according to the percentage of colored blood. In line with this, the laws of 4 states define coloreds as persons who descend from a Negro for up to 3 generations, even though one ancestor in each generation is white. 5 states make a simpler determination. Coloreds are persons who have 1/8 or more Negro blood. In 2 states we find the proportion to be 1/4. Occasionally, the smallest admixture of African blood suffices to give rise to the legal classification as colored. Other states permit outward characteristics to be decisive in determining membership in this or that population group. For example, former slave status, North Carolina, the fact of regular social association with one or another group, ditto, or, in the case of a second marriage, the racial identity of the first marital partner, Texas. Again, like Freisler, Krieger emphasized the open-endedness of American case law. The conceptualization of race in the courts is even more variable. A rare example of an extreme case of a judicial definition is a decision from Ohio which declares white persons to include those of more than half white descent. There is a growing tendency in judicial practice to assign a person to the group of coloreds whenever there is even a trace of visible Negro physical features, and beyond that, to do so when the Negro descent of the individual is common knowledge, without regard to how far the degree of descent reaches back. Here again, the memo that Gertner brought to the June 5th meeting presumably included this passage or something like it. It is true enough that Krieger's 1934 account was not about Jews as such. Indeed, it did not even mention them. But you would have to be willfully obtuse to deny that it was meant to inform Nazi policy discussions. It is particularly noteworthy that Krieger's article provided meat for the discussion of the variable conceptualization of race in American law of the kind that Freisler praised. In this regard, his article was typical. As we shall hear in a moment, there were plenty of Nazi observers who thought there was something to learn from the American approach to mongrels, even if the Americans had, so far, not understood the imperative of putting down their Jews. Nazi engagement with the American model continued over the subsequent months, leading up to the formal proclamation of the Nuremberg Laws in September 1935. Almost as striking as the discussion of American law by the Commission on Criminal Law Reform in the summer of 1934 is Herbert Keir's article on Folk, Race, and State in the National Socialist Handbook for Law and Legislation, whose treatment of American immigration law was already quoted in Chapter 1. More quotes are in order here. Keir began by alluding to the foreign incomprehension of Nazi goals. The National Socialist ideology presented here and the conclusions that must be drawn from it have been widely met with complete misunderstanding, and National Socialism and the German folk have been the targets of serious attacks. This is all the more incomprehensible since the United States of North America in particular has introduced statutory regulation in many areas that grow out of the racial point of view. In this regard, it is worth observing that the dominant political ideology in the USA must be characterized as entirely liberal and democratic. With an ideology of that kind, which starts from the fundamental proposition of the equality of everything that bears a human countenance, it is all the more astonishing how extensive race legislation is in the USA. Let me provide a few examples. The laws of the following American states forbid marriages between white and colored races. Keir then printed a 2-page alphabetical table with exact description and citation of the anti-miscegenation legislation of all 30 of those American states. That table corresponds to the description of American law given by Gertner and Freisler the previous June, and it seems a fair guess that it was one of the sources of their detailed information on American law, very likely the list to which Freisler referred at the June 5th meeting. The same table would continue to circulate in later years, reappearing in a standard commentary on the blood law. After printing it, Keir continued, "Thus the 30 states listed here all have prohibitions on miscegenation, which, with a single exception, all pursue the aim of safeguarding the American population of European origin against race mixing with non-European races. Only in North Carolina is there in addition a prohibition on miscegenation between Indians and Negroes. Extramarital sex between members of different races is also forbidden in several states, or even subjected to criminal punishment, for example in Alabama and Arkansas. Here we have it again, detailed Nazi engagement with the specifics of American law. Keir's next topic was segregation. He expressed some astonishment at the lengths to which American segregation was sometimes taken. In most of the southern states of the Union, white children and colored children are sent to different schools following statutory regulations. Most American states further demand that race be given in birth certificates, marriage licenses, and death certificates. Many American states even go so far as to require by statute segregated facilities for coloreds and whites in waiting rooms, train cars, sleeping cars, streetcars, buses, steamboats, and even in prisons and jails. In several states, as in Florida, only whites can be members of militia, yet in others, as in Arkansas, voter lists are separated by race, and in the same state, whites and coloreds are separated on the tax rolls. Keir clearly found all of this strange and a shade excessive. We shall hear in a moment more examples of Nazi authors who thought American law went overboard. At any rate, what American law demonstrated, Keir wrote, was how natural and inevitable racist legislation was. This variegated abundance of statutory racial regulation in the states of the Union demonstrates that the elemental force of the necessity of segregating humans according to their racial descent makes itself felt even where a political ideology stands in the way, a political ideology that denies that human beings have different worth depending on their descent. A very brief overview of American race law is given by H. Krieger in the Verwaltungsarchiv. It was from there that Keir moved to his peroration, identifying America as Nazi Germany's forerunner despite its liberal and democratic ideology, as the country that had arrived at the fundamental recognition of the evils of race mixing, now to be carried to its logical fulfillment in the Third Reich. Once again, it is important to reject the idea that all this was somehow meant as mere propaganda, directed at foreign readers. Keir certainly did refer to international misunderstanding of the regime, but this chapter cannot have been meant for a foreign audience. This was another dense text in Fraktur, probably with limited foreign circulation, intended to guide and inspire domestic Nazi deliberations. We should hear in Keir's reference to the outside world not an exercise in propaganda, but a kind of honest bewilderment about foreign misunderstandings of a scheme that was very close indeed to what was found in the United States. And we must remember that the Nazi regime at the time was not preaching extermination. What it was preaching arguably did represent a logical extension of much of American race law, much though we may want to pretend otherwise. Evaluating American influence. Like American immigration and citizenship law, American miscegenation law was thus a regular point of reference during the years when the Nuremberg laws emerged. The question remains whether we can say that the Nazis were in some meaningful way directly influenced by American miscegenation practice. The answer to that question is, inevitably controversial, yes. First of all, it is essential to reject once and for all the proposition that American law could not have been of interest to the Nazis because it did not expressly target Jews. The absence of Jews from American prohibitions did not deter Nazi jurists from investigating American law in the least. Yes, it is true that American anti-miscegenation law primarily spoke of Negroes and Mongols, but that hardly meant that American law had nothing to offer. Helmut Nicolai, the Nazi race fanatic with whom this chapter began, declared in a major 1933 speech that Negroes and Mongols represented a threat to racial purity just as Jews did, and the Prussian Memorandum spoke in the same vein not just of Jews, but of Jews, Negroes, or other coloreds. Radical Nazis throughout the early years of the 1930s were well aware that there was an American model to exploit, and they were quite willing to draw on American law in planning their fundamental constitutional law of the National Socialist State on interbreeding and sex. It is simply nonsense to claim that Nazi lawyers could not have made use of American precedents because of the absence of formal measures against American Jews. These were able lawyers who were quite capable of extracting legal techniques from statutes with goals somewhat different from their own. Once we dispose of that dubious claim, we can indeed and really must speak frankly of something that can only reasonably be called influence, as objectionable as that term is sure to seem. First and foremost, we can detect something that is entirely right to deem influence in the criminalization of racially mixed marriages. The blood law decreed both the civil invalidity and the criminality of mixed marriages. Law on the Protection of German Blood and German Honor. Section 1. 1. Marriages between Jews and nationals of German blood or racially related blood are forbidden. If such marriages are nevertheless entered into, they are null and void, even if they are concluded abroad in order to evade this law. Section 5. 1. Any person who violates the prohibition of Section 1 shall be punished by imprisonment at hard labor. The language of this law was certainly not directly copied from some American statute, but that is not the point. Legal influence on jurists as sophisticated as the Germans of the mid-20th century does not involve literal copying. Lawyers make use of larger conceptual frameworks while drafting language that suits their particular circumstances, and in this case the leading German lawyers of the early Nazi period framed their conceptual question as the question of whether marriage could ever be the subject of criminal law, outside the cases of bigamy and malicious deception. American law offered the great example of a Western system that criminalized mixed marriages. German jurists had known that since the early 20th century. They still knew it in the early 1930s, and they discussed the American sources in detail, both in print and in the critical closed-door meeting for which we possess a transcript. In particular, the radical Nazi Freisler who pushed for broad criminalization from the Prussian Memorandum on appears in that transcript as a vocal champion of American legislation and jurisprudence. Skeptics may retort that Nazi radicals would have succeeded in criminalizing racially mixed marriages even if they had not had an American example to cite. That is perfectly possible. We will never know. Nevertheless, there can be no justification for ignoring the evidence of Nazi engagement with American models that litters the sources. Even if the radicals were destined to win, that does not mean that having an American model meant nothing in the political battles of the early 1930s, nor that the radicals who cited American law over and over again were not in some significant way inspired by what they found. Only a naive and pedestrian understanding of law, only a dogged refusal to face facts, would dismiss the American example as insignificant in this setting. If we had evidence of this kind for any less freighted case in comparative law, we would not hesitate for a moment to speak of influence. Konrad Zweigert and Heinrich Krieger, the preeminent post-war German specialists on comparative law, give a standard account of how foreign law affects legislative innovation. Legislators all over the world have found that on many matters good laws cannot be produced without the assistance of comparative law, whether in the form of general studies or of reports specially prepared on the topic in question. Ever since the second half of the 19th century, legislation in Germany has been preceded by extensive comparative legal research. Like other post-war German scholars, Zweigert and Kurtz pass over the Nazi period in silence, but their description of how laws are made is equally applicable to Germany in the period 1933 to 1935. It is just as pertinent to the making of bad laws as it is to the making of good ones, and the extensive comparative research conducted by the Nazi lawyers of the early 1930s inescapably links America to the making of the Nuremberg Laws. Defining mongrels, the one-drop rule and the limits of American influence. America's role is clearest in the case of the criminalization of racially mixed marriages, but the American example also mattered for Nazi discussions of the classification of racially inferior mongrels. American law was concerned with defining Negroes, just as German law was concerned with defining Jews, and Nazi observers were well aware that the United States offered a possible model. Lawyers were by no means the only Germans intrigued by American racial classification schemes. For example, there was this passage in a 1934 book that was published as a guide for teachers on how to present Nazi race policies to their pupils. The author observed that Americans took the need for racial purity so seriously that they were prepared to take what even Nazis regarded as exceedingly harsh classificatory measures. Sharp social race separation of whites and blacks has shown itself to be necessary in the United States of America, even if it leads in certain cases to human hardness, as when a mongrel of predominantly white appearance is nevertheless reckoned among the niggers. This was the world of the American one-drop rule, disturbing even to Nazi commentators who shuddered at the human hardness it entailed. Another Nazi author, this time in an article written for English teachers in 1936, had similar words. He praised the American commitment to legislating racial purity, but he too blanched at the unforgiving hardness of the social usage according to which an American man or woman who has even a drop of Negro blood in their veins counted as blacks. The one-drop rule was too harsh for the Nazis, or at least for most of them. The fanatical Achim Gerke was in favor of something like it, and for that reason alone the influence of American classification schemes was inevitably limited. The scholars who see parallels between American and Nazi racial classification schemes are, to that extent, wrong, but only because they understate the relative severity of American law. The Nazi literature saw other obstacles as well. German Jews were simply not American blacks. American blacks, as one anonymous author explained in 1935, were generally physically recognizable as such, and that meant that America could rely on mostly clear color lines. Identifying Jews was far tougher. Unlike blacks, Jews maintained their communal identity by their culture, not their color. American blacks, by contrast, had lost all of their distinctive culture after centuries of oppression. The Negroes, having lost their cultural traditions, are now held together only negatively by their identifying physical features. What the Jews and the Negroes of the USA have in common, however, is the will to become outwardly assimilated. In this regard, the prospects of the Jews are seemingly better, since the bodily differences do not stand out visibly as strongly and, accordingly, can be hidden more successfully. Germany's Jewish problem was far more insidious than America's Negro problem. The German Jews, this author worried, would find it all too easy to infiltrate themselves into the community by pretending to embrace the German characteristics of diligence, love of orderliness, and thrift. America was different. There were limits to the possible extent of American influence on Nazi racial classifications, and Nazi authors were quite conscious of them. Nevertheless, American racial classifications were of inevitable legal interest. That was a large part of the appeal in American miscegenation law. We see that in Justice Minister Gertner's report on how American law defined the races. We see it in the handbook article on Folk, Race, and State, carefully listing for its Nazi readership which American states defined blacks as those with which fraction of black blood. We see it in Johann von Leer's 1936 review of the laws of the American states. We see it in Krieger's 1934 article, and later in his 1936 book. And at least one aspect of American law may have carried some weight in the German debates. American states did not define mongrels strictly on the basis of descent. As Krieger explained, race classifications in the United States might also turn on other factors. The courts of some American states, in particular North Carolina and Texas, looked to other outward characteristics. Texas in particular considered marital history. Outward characteristics may be decisive in determining membership in this or that population group, for example, former slave status, North Carolina, the fact of regular social association with one or another group, ditto, or in the case of a second marriage, the racial identity of the first marital partner, Texas. The idea that race classifications might turn on something other than descent, and in particular on marital history, deserves to be flagged. That idea was of critical importance in the ultimate Nazi definition of Jews. As we have seen, radicals wished to define Jews as those with only a single Jewish grandparent, the equivalent of what American states would call one-fourth colored. As early as April 1933, however, there was a counter-proposal on the table. This alternative classification scheme proposed to spare half-Jews, unless those half-Jews either practiced the Jewish religion or entered into a marriage with a Jew. It was that counter-proposal that ultimately made its way into the crucial implementation ordinance of the Nuremberg Laws. First regulation issued pursuant to the Reich Citizenship Law, November 14, 1935. Section 5. 1. A person is a Jew if he descends from at least 3 grandparents who are racially full Jews. 2. A person counts as a Jew if he is a mongrel descended from 2 fully Jewish grandparents, A, who at the time of the promulgation of this law belongs to the Jewish religious community or is subsequently accepted into it, or B, who at the time of the promulgation of this law was married to a Jew or subsequently married a Jew. Minor other provisions follow. Thus, the moderates managed to shield some, but only some, half-Jews. Lösener justified this compromise by holding that life choices were relevant because they revealed the inclinations of the mongrel in question. The half-Jews who counted as Jews were the ones who were not submitting to German cultural values. Also reckoned among the Jews are certain groups of half-Jews, persons with 2 full Jewish and 2 non-Jewish or not full Jewish grandparents, who on account of certain circumstances must be regarded as more strongly inclined toward Jewdom. Did the American example count for something here? Krieger's article was not the only possible source for the notion that a juristic solution to the problem of classifying Jews might turn in part on marital history. As we have seen, the Nazi literature on American immigration law praised the American Cable Act rule denaturalizing women who stooped to marry Asian men. It may have mattered in the charged debates of the weeks after the promulgation of the Nuremberg Laws that America, the model of a country with anti-miscegenation law, offered some support for the notion that marital history should play a role in assigning persons to one racial category rather than another. In the end, though, we do not know. We cannot say what part, if any, this aspect of the American model played in German thinking. The bottom line is that the Nazis regarded American classification schemes as too harsh, and the American race problem as too different for any unmodified borrowing to have taken place. But what ultimately matters is that they knew there was an American example, and indeed the example that they turned to first and over again.